Hello everyone and welcome. Thank you for joining us today. My name is Diana Bowman. I'm a Community Development Officer for PAVO. My colleague George Stroud, who is also a Community Development Officer at PAVO, is helping with the technical support today. We're running a poll to check that everyone can see and hear me. And if you have any questions, you can ask them along the way by writing them down. George will address these. Any questions which we are unable to address during the session, we will get the answers over to you afterwards. Okay, so this webinar is about the General Data Protection Regulations which came into force in May. The learning outcomes from today. The session aims to provide an understanding of the legal responsibilities organisations have under the new legislation, details about data inventories and the new legal portals, privacy notices and obtaining consent, and where to find resources and templates. GDPR is a European law which came into effect on the 25th of May. It replaces the Data Protection Act 1998. In the UK, the regulators of GDPR is the ICO, the Information Commissioner's Office, and it will still be law post-Brexit. The new GDPR strengthens the rights of individuals over their personal data. It provides greater transparency of what data is being held and how it is used. It places obligations on organisations to assess risks and protect the data better. And organisations must report breaches to authorities and in some cases individuals within 72 hours of becoming aware of the breach. Like the Data Protection Act 1998, the DPA, GDPR applies to personal data, but the definition for that has been expanded. Under the GDPR, personal data means any information relating to a living person who can be directly or indirectly identified from that information. It also applies to sensitive personal data, which it refers to as special category data. These categories are subject to additional protections and include data such as genetic data, health and medical information, ethnic origin, political opinion. Data relating to criminal convictions or offences is not classed as special category data, but there are separate safeguards in place for this type of data within Article 10 of the GDPR. So, will you need to comply with it? Yes. If you work or volunteer for an organisation or business that processes personal data, then it is likely you will need to comply with the GDPR. If your organisation processes personal data relating to EU residents and it is classed as being either a data controller or a data processor, your organisation will be required to be GDPR compliant. A data controller is the organisation or person that collects and uses personal data and decides the purposes and means of processing that data. A data processor is the organisation or person responsible for processing personal data on behalf of a data controller. So this might include organisations providing services such as payroll management, mail delivery and IT systems. The GDPR places specific legal obligations on data processors which have not been in place under the DPA, the 1998 Act, and processors will now have legal liability if they are responsible for a data breach. However, the ICO don't want everyone to panic. They say the message we really want to get across is it's not all about the 25th of May. We're not out to get people and it's not all about fines. Although it's enforced, we're not going to go and start fining all the small organisations, which I think is the big worry charities have. As we all know, life's a journey and so is GDPR. We are all on that journey together. So what's the difference between the DPA 1998 and the GDPR? There are many similarities between the two pieces of legislation, but the GDPR has introduced a number of new provisions that you'll need to be aware of. We'll go through these in further detail. The number of data protection principles has been reduced from 8 to 6, but they do remain very similar in content to the 8 principles set out in the DPA. The 6 principles of data protection that are now set out under the GDPR state that data shall be processed lawfully, fairly, and in a transparent manner in relation to individuals, collected for specified, explicit, and legitimate purposes, and not processed in any manner that is incompatible with those purposes. Adequate, relevant, and limited to what is necessary in relation to the purposes for which they're processed. Accurate, and where necessary, kept up to date. Kept for no longer than is necessary for the purposes for which the data is being processed. And processed in a manner that ensures appropriate security of the personal data using appropriate technical or organisational measures. The GDPR also sets out an overarching principle of accountability. This requires data controllers to be responsible for and be able to demonstrate compliance with the 6 principles set out above. GDPR makes privacy by design a legal requirement under the term data protection by design and default. In other words, build it into your projects from the start rather than bolting it on as an afterthought. Keep a record of your processing activities. Implement suitable technical and organisational measures. Systems should include a data inventory, record keeping, data protection impact assessments, which are a tool to help an organisation identify and minimise data protection risks and find effective ways to comply with their data protection obligations and meet individual expectations of privacy. The GDPR make it mandatory for these impact assessments to be carried out for certain types of data processing, or if the processing of someone's data is likely to result in a high risk to that individual's interests. It's worth noting that data protection impact assessments could be relevant to funding bids to show that your organisation has carried out an impact assessment. Templates for this and further information can be found on the ICO website. Data protection officers, under the GDPR, if you're a public authority or your core activities require large-scale monitoring of individuals, or your core activities consist of processing special categories of data, or data relating to criminal convictions or offences, then your organisation will need to legally appoint a data protection officer. Otherwise, you can appoint someone to be your organisation's data protection lead or similar, so that they coordinate data protection provisions within your organisation. Before you can process any personal data, the GDPR requires you to identify a valid, lawful basis for being able to process it. There are 6 bases that you can choose to rely upon, and you will need to determine which one or more applies to your data processing activities. The ICO's Lawful Basis interactive guidance tool can help you with this. The 6 lawful bases that are available for processing data are consent. The individual has given clear consent for you to process their personal data. Contract. The processing is necessary for a contract that you have with the individual, or because they've asked you to take specific steps before entering into a contract. Legal obligation. The processing is necessary for you to comply with the law, but this does not include contractual obligations that you may have. Vital interests. The processing is necessary to protect someone's life. Public task. The processing is necessary for you to perform a task in the public interest or for your official functions, and the task or function has a clear basis in law. This is most relevant to public authorities, but it can apply to any organisation that exercises official authority or carries out tasks in the public interest. Finally, legitimate interests. The processing is necessary for your organisation's legitimate interests or the legitimate interest of a third party, unless there's a good reason to protect the individual's personal data which overrides those legitimate interests. So those are the legal bases. Previously, under the 1998 Act, if you were relying upon consent to process an individual's personal data, in most circumstances you could rely on either express consent, where the individual opts in to using their data in specific ways, or implied consent, where the individual doesn't opt out. Under GDPR, if you wish to rely on consent as the lawful basis to process personal data, you will no longer be able to rely upon implied consent. It will have to be opt-in consent, which is freely given, specific and informed. This means the threshold for consent is higher under the GDPR, so you might need to alter the way in which you gain consent from individuals or renew their consent, if consent is needed for you to process their data. And the ICO have published a guidance just on consent. As we've just seen though, consent is only one of the 6 options that you have for processing personal data, and it might be more appropriate or practical for you to rely on a different legal basis. So bear that in mind. Enhanced rights. The DPA provides individuals with a variety of rights in relation to their personal data, but those rights are enhanced by the GDPR and include a new right of data portability. The following rights for individuals are set out within the GDPR, and they are the right to be informed, the right of access, the right to rectification, the right to erasure, the right to restrict processing, the right to data portability, the right to object, and rights in relation to automated decision-making and profiling. Again, full details of those rights can be found on the ICO's website. Privacy notices. A privacy notice is a statement that you provide to individuals when you collect information from them, setting out what they need to know regarding data protection. The GDPR introduces a requirement for more detailed privacy notices to be provided to individuals when personal data is collected, including information such as what information is being collected, who's collecting it, how you collect it, how long you keep it for, the legal basis you're using, how is it going to be used, will you share it with anybody, the individual's rights, and the contact details for the lead, the person responsible for data protection in your organization. You also need to consider if the intended use is likely to cause individuals to object or complain. A personal data breach is a breach of security which leads to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of or access to personal data. It includes breaches that are the result of both accidental and deliberate causes. GDPR introduces a duty on all organizations to report certain types of personal data breach to the ICO, and they must do this within 72 hours of becoming aware of the breach. If you're uncertain whether it's a breach or not, ask the ICO. If the breach is likely to result in a high risk of adversely affecting individuals' rights and freedoms, you must also inform those individuals without undue delay. Failure to report a breach to the ICO may result in a fine, as could the breach itself. With fines, the maximum fine under the DPA was £500,000. The GDPR introduces an increase in the level of those fines possible for failing to report the breach and or for the breach itself. The maximum penalty could be up to €20 million or 4% of global turnover, whichever is the larger. The ICO have, however, confirmed that they will only impose fines as a matter of last resort, as they do now. Along with the power to issue higher fines if they feel that is necessary, the ICO will continue to be able to issue other sanctions, including warnings, reprimands, and corrective orders. So, what can I do to ensure my organisation is compliant with the GDPR? There are a number of steps that you can take to ensure that you're compliant. Step 1, ensure that everyone in the organisation, trustees, volunteers and staff, know about GDPR. Appoint someone in the organisation to be responsible for data protection. Step 2, identify and document the information you hold and what you do with it. The type of data, personal or special category, where it came from, who you share it with, Organise your data so it is stored in an organised fashion. If someone says, "What data do you hold about me?" you need to get it to them quickly and accurately. Don't hold on to data unnecessarily or just in case. You can't hold it if you don't know why or how you're going to use it. The ICO have a number of documentation templates and checklists that you might find useful. Communicating data privacy information, saying who you are, how you're going to use their data, who you'll share it with. This is all done through a privacy notice. Individuals have the right to be informed. Set out a privacy notice in a clear and concise way. Privacy notices must now include the legal basis for holding the data, the categories of data you hold, how long you'll keep it, which is called the retention period, and the source of the data if it's not from the individual. This is an example privacy notice devised by the ICO, showing the purpose of processing data, the information required, and the legal basis used in different situations. Step 4, be aware of the enhanced rights of individuals, which we went through earlier, in relation to their personal data. Ensure procedures are in place to adhere to and respect these rights. For example, what would you do if someone asked for their data to be deleted from your database? Have you got the systems in place to do this effectively to ensure they don't hear from you again? GDPR changes some of the rules regarding individuals asking about the data you hold about them. For one thing, there is no fee. You need to have a system for providing the information you have on a person and any supplementary information you might hold. If they ask, you need to supply it within 1 month and free of charge. And if you refuse, you must be able to say why. Step 6, you must have a valid legal basis for processing data. This must be recorded in your privacy notice, but you must also be able to justify your reasoning for relying on that basis and be able to evidence it, depending on the basis used. Step 7, consent. One of the legal bases. Do you need it? Allow people to positively opt in to your storing their data. So people have to actively say, yes, you can have my data, and yes, you can use it for these reasons. If collecting data in person, get them to sign a form or tick a box. Have evidence of opt-in so you can show they have agreed. GDPR raises the standard you are required to meet if relying on consent for holding data. It must be freely given, specific, informed, unambiguous, and granular. For example, consent for each different type of data. Under the GDPR, consent cannot be inferred from silence, pre-ticked boxes, or inactivity. So you check how you record consent on an ongoing basis. It must also be simple for people to withdraw consent. In your emails, make it easy to unsubscribe. By post, say how people can stop receiving information. Ensure that once they've opted out, they won't receive any more correspondence from you. Step 8, children. You need particular protection when collecting and processing their personal data because they may be less aware of the risks involved. Consider whether you need to put systems in place to verify individuals' ages and to obtain parental or guardian consent for any data processing activity. You'll need to get consent from whoever holds parental responsibility for a child under 13, unless you offer an online counselling service. Write clear privacy notices for children so they understand what happens to their personal data and what rights they have over it. As we said earlier, GDPR introduces a duty on all organisations to report certain types of personal data breach to the ICO and within 72 hours of becoming aware of the breach. If the breach is likely to result in a high risk of adversely affecting individuals' rights and freedoms, you must also inform those individuals without undue delay. Failure to report a breach to the ICO may result in a fine, as could the breach itself. So you record the safety measures you put in place so you can show you've taken precautions. Ensure data is safely secured so it can't be leaked, hacked, or stolen. Install antivirus software. And if you have hard copies, lock them away and ensure no one unauthorized can access them. Step 10, GDPR makes privacy by design a legal requirement under the term data protection by design and default. So build it into your projects from the start rather than as an afterthought. GDPR also makes data protection impact assessments mandatory in some circumstances. This is the tool to help an organization identify effective ways to comply with their data protection obligations. Carry out a DPIA when you're using new technologies. The processing is likely to result in a high risk to the rights and freedoms of individuals. If unsure, check the ICO guidance on their website. A data protection officer is required if an organization is a public authority, it carries out large-scale systematic monitoring of individuals, or it processes large-scale special categories of data. Otherwise, your organization needs to have someone responsible for data protection as part of their role. Step 12, sharing data with a company outside the EU. You need to ensure that data is safe when it lands in another country, for example, using MailChimp, iCloud, or SurveyMonkey. Google are already signed up to EU GDPR. Oh, and finally, how does GDPR impact on health and safety? Just kidding. Here are some useful links for further information and templates from the Information Commissioner's Office. And that's all. Have you got any questions? Oh, hang on, I've just lost. Thank you very much for attending. There are contact details if you have any queries afterwards. Yes. So we have devised some templates which we can send out to all of you. In particular, a spreadsheet which helps you with data mapping and checking which data you hold and what you do with it. George is going to bring this up on screen now so that we can go through it. And if you have any questions, you can ask.
Yes, I do. Right. Sorry, apologies about that. So I'm hoping that now you should be able to see the spreadsheet. So the first page, you're starting off by identifying the various types of data that your organization is holding. You're then asking a series of questions about each of those types of data. So you have to answer the question of why is it held? You need to consider which people hold it. You need to consider how do they use it? And then do they share it? Because then you'll have to be considering whether or not the people that they share it with, any external processors, are then compliant and that you have the correct agreements in place with them. Also kind of considering what format it's stored in, which will then later help you to answer questions about the security of that data. So when you fill in some kind of data here, it then populates the 3 other tabs on the spreadsheet, which are kind of further levels of detail. So after you've dealt with the kind of who, why, what of the situation, you can move on to the handling processes. So then it'll ask you questions about how do you go about collecting that information? How does that data then flow through the organization? Who has access to it at which point and for what reasons? And is it always through that same database, or do you actually have does it end up in 2 places that you then have to keep an eye out for? Again, how is it used and who handles it, so that you know who's responsible for it? Once you've dealt with those questions, you can consider the safeguards that are in place with respect to that data. You can look at whether that data is password protected everywhere that it is held. So that's very important to make sure that people can't step into a room, happen to access a computer and just get a hand on that data. Making sure that the machines where the data is held, as Diana mentioned earlier, have kind of security patch management in place. That would be your Windows updates, say, for a lot of you. Making sure that there's some kind of antivirus installed on the computer and that it's kept up to date, obviously. and then also checking that all of the people who run those machines, who use those machines, are sufficiently aware of the most obvious kind of internet threats that can get around those things. So that would be included kind of odd emails, suspicious links, websites with pop-ups that ask you to download stuff, that kind of thing. Just reiterating and making sure that people have that awareness, so that just even if you have the best security in place on the machine, sometimes if people behave in risky ways, that won't be good enough to make sure that the sensitive data isn't breached. The last sheet here is about all about making sure that you're keeping up to date with your consent. You're keeping up to date with your removal if data if it passes the point whereby you've said that you're going to remove it from your database. And the last tab there is a little thing about consideration given. So it's, for example, making sure that you are clearing out your database of people perhaps who have died, so that you're not trying to contact people who are no longer alive, because that might be unsympathetic to relatives and so on. They're not completely obvious, but there are some little extra notes where there's a little orange arrow on a column heading. You'll see that there's a little extra kind of tooltip or a note that I've made that explains the column header. And this spreadsheet will feature as part of the resource pack, which we'll be sending out to you after we've finished with the webinar. I know, I think it was Andy earlier was saying that we'd put the handout, which are the slides that go with this session, we'd put up as a handout on this webinar platform. He said he was having a little problem accessing that too. So we'll make sure that we send that out at the same time as we send out the resource pack. All of this stuff will also be available on our website if anyone else needs to get access to it. I'm going to hand back over to Diane to wrap up, I think.